Hi, I'm Ashley with Campbell. Thanks for investing your time to help your community be a great place to live. Before you watch the video, make sure to click the subscribe button so that we can help you make educated decisions as a board member.
Welcome, everyone. Thanks for joining us today. Hi, I'm Dan Tiernan. I'm one of the 5 owners of Campbell Property Management, and I work closely with a lot of our condo clients on a regular basis, especially on major issues that they face from time to time. I'm also a licensed CAM. So today's course is specifically for condominium association board members. I think this will be the 3rd time we've said that. So if you're a board member for an HOA, this course is not for you. So a little bit about Campbell. We've been in business since 1953, and today Campbell manages over 400 condos and HOAs between Miami-Dade County to the Treasure Coast. We take great pride in our work, and it shows in our retention for both employees and customers, and we renew 98% of our clients annually. We pride ourselves on our reputation, which shows in our online reviews as South Florida's highest rated property management company. So before we start on the board certifications course, I'm going to start with some key tips on 3 areas. Number 1, where you can find answers about issues you may have to deal with at your condo. Number 2, how to be a great board member and make your community a great place to live. And 3, how to run an effective board meeting. So this will take about 15 minutes. And then after that, we'll go through the board certification course. So our legal expert today is Steve Braten. Steve is a shareholder with Rosenbaum, one of Florida's leading firms specializing in condo and HOA law, and one of the best in the field. We work with him at many properties. So after my brief presentation, Steve will introduce himself and his firm in more detail. So as I mentioned, before we start the board certification, I'm going to briefly cover 1, why you're here, and 2, some educational resources related to condominium management. And then we're going to talk about 7 things you can do to be a great board member, and then 9 steps you can follow to run an effective board meeting. So first of all, why are you all here today? Well, as a new board member, you're legally required to satisfy one of 2 requirements. You need to either attend a board certification course, which is focused on the law, which you're doing today, or you can read all your community governing documents and sign a document confirming you've read them. So we recommend you do both, that you attend the board certification like you're doing now, and also it's a great idea to read your governing documents and make sure that you fully understand them. So, if you want to be a great board member, there's not enough time to teach you everything in a 2-hour course, but our goal is to get you started and point you in the right direction. So the first thing you need is the basic understanding of the relevant laws related to managing your association, which is going to be covered by Steve here shortly in the certification course. But then you also need to learn about other key operations and activities in your community, kind of understanding the actual operations from a day-to-day standpoint. Ultimately, the board is responsible for, board meetings, financial preparation, budget preparation, annual meetings, the maintenance of the physical property, and much more. And a lot of this will get delegated to your manager, but ultimately that's your responsibility. And then also, it's important to understand your actual role as a board member and what your responsibilities are, and for whether you're a director or an officer. So, obviously you guys are all volunteers, and this can be overwhelming if you've not been on a condo board before. It's very different than any other kind of board that you might have been in the past. So our goal again in this short presentation is to help make it easier for you by providing some really good informational educational resources in the form of online educational courses that we offer that I'll talk a little bit about, a newsletter and blog, a library of past courses. So we keep the history when we talk about the things. You can go back and look at things in the past. You don't have to just do it live. And then finally, a short 4-page board member primer, which we'll send you at the end of this presentation. It kind of gives you an overview of your role as a board member. So regarding these events, so if you're interested in past courses we've conducted or future courses, campbellevents.org is where board members and managers can find out and register for upcoming educational webinars. As you can see from this page, there's several classes every month. Today's class on condo board cert. There's one tomorrow on tree trimming. It actually is good for managers as well if they want to get CEU credits. There's another one next week on 9 steps to an effective board meeting that's going to go in more detail over what we're going to do at a high level today. And there's one on EV charging stations on the 28th that we'll be doing as well. So make sure you go there if any of these sound interesting, and maybe there's some others that you might be interested in the future. They're all free, they're all online. So board members also have access to past educational webinars. We had 2 related to insurance and 1 related to electronic voting in December. This is just a short list of some of them that you can see. And there's been a lot of things happening with insurance, over the last couple of years. Obviously, these rates have gone up dramatically. Market's gotten a lot more complicated, and some of these webinars help explain that in great detail. So finally, one other tool on Florida Association News or FAN is a search engine, which provides content on community association topics. So in this little example here, I put in the word movies, and the search engine shows 4 different articles from 3 different sources that explain legal considerations when you're hosting movie nights in HOAs or condos in Florida. So if you put movies in Google, you're going to get a very different result. So what we did here is, instead of searching the entire internet, we've identified about 100 websites that are focused on community associations in Florida specifically, and we limit the search engine to those sites, which makes finding the information you're looking for a lot easier than just going on Google and trying to find it that way. So aside from the legal considerations, there are also a lot to learn from an operational standpoint, and Campbell's board member primer that I mentioned earlier was designed precisely for this purpose. The primer is a concise 4-page document that provides a brief overview of community management, including your roles as board members and officers. And it also highlights all the Campbell educational resources available that I just mentioned to you earlier to help you understand community operations. And we'll be sending a link to access the primer to you via email after the webinar. Just a little bit more about the contents of the primer. It includes an overview of the community association concept and what you should expect as a director, an explanation of your roles and responsibilities, including each officer position. What precisely are the responsibilities of the president, secretary, treasurer, vice president? A high-level overview of your fiduciary duty, more commonly known as your responsibility to act in the best interest of the community. Steve will talk about that in great level of detail in his course. Number 4, an overview of Florida Association News. This is our educational resource, Florida Association News or FAN, that we talked about earlier. And then finally, there's 13 featured blog posts specially selected to address some of the most common concerns for board members. So we're going to spend the rest of this session to give you an idea of what you'll be learning from the primer. So near the end of the primer is this list of 13 highest recommended blog posts for board members. And if you see, the top 2 that we have here are especially important. So the first one is 7 habits of highly successful board members. Now, these are some of the best habits we've seen in the most successful board members we've worked with. And just to go through these briefly, and again, we have other webinars on this that go through it in much greater level of detail, but at a high level, number 1, it's putting your community interests first. This is all about your fiduciary responsibility to look out for the best interest of the community. So even if you don't swim, you should make sure that you still are thinking rationally about replacing old pool furniture or adding shade structures that people are asking for, or you don't want to be in a situation where you don't want to spend the money to convert tennis courts to pickleball because you don't play. It should be more about what is this going to do to the enjoyment of the owners, and the long-term property value is what you need to be ultimately thinking about. And number 2 habit here is seeking consensus. So the best board members aren't necessarily the best politicians or the smartest people or the ones with the most experience in a certain trade. It's really about the people that are really good at seeking compromise and finding ways to bring people together towards a common goal. So, some of the things you can do here are, if you know you've got a controversial topic coming up on an agenda, don't wait for the meeting to hash this all out in front of everybody. Have one-on-one conversations or short Zoom sessions with people one-on-one or maybe in small groups to make sure you don't get the quorum, and kind of talk through these things in advance to try to see if you can find some common ground. Compromise is the absolute key to success on a board, and you want to make sure that you don't let perfection be the enemy of good here on this. Number 3 is investing in your community. So a key responsibility of the board is to maintain the property values of the community, which means investing in the common areas and potentially making capital improvements. So if your board's claim to fame is that the maintenance hasn't gone up in 5 years, something's probably wrong and you're kicking the can down the road. Remember, the purpose of the board is to maintain and enhance your property values, and you need to look at, you have that fiduciary responsibility from a long-term standpoint to make your community a great place to live for all the owners. And number 4 is trust your manager. Actually, trust your manager and other professionals, honestly. So property managers are licensed professionals with years of experience in their field. And good managers don't want to be micromanaged. So if you can't trust your manager, then you likely have the wrong manager. So at the same time, you need to understand that they are not the experts in everything, and you need to respect when your manager tells you to bring in a legal counsel on a difficult issue, or bringing in an engineer if there's some structural issues that need to be dealt with, or a project manager, and so on. So this is a minor added cost that can save you from making 5- and 6-figure mistakes down the road. Number 5 is over communicate. The number one complaint we hear from owners that might want to run for the board is lack of transparency, just not being open with what's really happening. So effective communication with residents is essential. So there's a lot of different ways you can do this. You can use email, you can do newsletters, you can do monthly reports. When there's a big issue facing the community, one of the best things you can do is be proactive and get in front of the owners, before that's dealt with or before it becomes, finalized. And you can use town halls to do that. Bring in the experts. If it's about a big special assessment project, bring in the engineer, bring in the attorney to explain the necessity for the project and then why you're doing what you're doing. Make sure that everyone understands, so that they don't complain about it later. And number 6, play by the rules. So rules are not made to be broken in condo or HOA, and it's important to lead by example. The worst thing you can do is appear to be selective in how you're enforcing things, and the best way to make sure you do that is to have a consistent process and routine that the manager follows to make sure that violations are uncovered and reported on a regular, consistent basis. You don't want to ever make it feel like there's any kind of possibility of selective enforcement. And then number 7 is honestly the most important one. Just be a good neighbor. You have to remember, unlike other boards, when you're in your community board, your condo board, you're not just a shareholder, you're also everybody's neighbors. So treat your neighbors the way you want to be treated. If you can, try to stay off social media like Facebook and Nextdoor, and accept the fact that you're going to get a little bit of criticism here and there. And the best thing you can do to try to combat that is that good communication, number 5 up earlier. Get ahead of them, communicate clearly, make your communication so clear there's no need to have a secondary area for communication. So those are the 7 things that you need to do to be a great board member. And then the next thing we want to talk about is running an effective board meeting. So if you run a good board meeting, it instills faith in the owners that you're doing a good job, that you guys know what you're doing as a board. And if your meetings are dysfunctional, it makes you and the rest of the board look really bad. So some of the key things you need to do to avoid this and to make sure that you do have a good meeting is number 1, preparation. This is all about having a proper agenda and board package. If an item isn't ready to be discussed in front of the whole community, don't put it on the agenda. If the board's voting on something, they should have and they should also make sure they have all the necessary information at least 48 hours in advance via the board package, making sure you don't want to look like you're just discovering and learning things and hearing things for the first time as a board member in these meetings. It really should be kind of all thought out before that happens. And number two is making sure you have the right equipment. So lots of communities are, in the past, it was just about having speakerphones. Now, lots of communities want to do hybrid Zoom meetings where, you've got people in person and then you want to let people participate remotely as well. You've got to make sure you've got the right hardware and software to be able to do that effectively and test it in advance and make sure that it really works, because no matter how much you spend or what the quality of the community, if you don't have it set up and figured out how to use it effectively, it's going to be a problem for you. The next is establishing time limits. So, this is when I'm saying this, I'm saying less about the owner's right to speak, more about think through how long your meeting is going to last. That if you're going to have a certain topic that shouldn't take more than 5 minutes to get through, this one shouldn't take more than 5. Oh, this one might take 30 minutes. If it takes 30 minutes, probably shouldn't be on your agenda. So just thinking that through and talking it through with the boards in advance, letting people know how much time you should have to try to make sure you can get through the meeting in a reasonable amount of time. And the next thing is declaring the ground rules. So I highly recommend establishing ground rules for every meeting, announcing them and following them for every meeting. So that way, whenever a controversial issue comes up, there's an expectation of how the meeting will be handled, and people will know that they have an opportunity to speak. And this also helps out for, you want your new neighbors, your new owners, when they come, you want them to understand the way these meetings work. You don't want to have to call them down for doing something wrong because maybe they think it's a town hallish kind of format. So you just make sure everyone understands right out of the gate before you get started. Number 5, and this is a super important one, but pretty common sense, is following the agenda. So make sure you stay on topic and discourage tangents. So have someone whose job it is to keep the meeting on track. So board meetings shouldn't take 2 or 3 hours. And if there's an item on the agenda that really shouldn't be, if the item's not on the agenda, you shouldn't be discussing it, because Steve will get into this later on, but it's not legal to talk about things that are on the agenda. That's the whole point of publishing an agenda in advance. The next one, real important one, making sure you let members speak. Members have a right to speak on agenda items, just agenda items. Again, it's all you should be talking about. I recommend the following format for a discussion on agenda items. So once the motion's made and discussion is open to board members, and once board members have discussed, the floor is open to residents who might want to speak on the topic. And once the residents have had a chance to ask questions, the board discusses one final time before they proceed to a vote. So this is a respectful way of doing it. You might have some experts out there that know something that you don't know. It's always a good idea to do it before you make the vote. Number 7 is about Robert's rules. And this is really just making sure you're using it reasonably. There's a lot of people that are kind of real experts in this, and you really don't need to be. You really want to use the basic tools of opening the meeting, taking roll call, dealing with old business, reviewing prior minutes, new business, making sure the motions are done right, et cetera, keeping it really simple. You don't have to be an expert in this to do well with it. So just make sure that you don't get carried away. And number 8 is a real important one. This is the Dale Carnegie point: don't criticize, condemn, or complain. So, you're going to have people that are going to be disruptive on occasions. So if there's a topic that's coming up that's going to be controversial, or there's some people that are upset in the crowd, just anticipate it, try to talk to them in advance and try to address their questions before the meeting. And if they start yelling at you during a meeting, just be prepared and try to bring it down. Don't be an amplifier, be a filter. Try to lower it down and keep people calm. And number 9, which I'm sure Steve will talk about in more detail as well, is making sure you understand minutes are not transcripts. So your minutes should be very simple, just like what I talked about earlier. When the meeting started, the roll call, the prior minute approvals, old business, new business, simple motions, who voted for what, and so on. You do not want to have, you do not want to have a lot of commentary in there and content. This could be a real problem for you from a legal standpoint down the road. And this is just this is an example for the minutes specifically. This is a featured blog post on the primer that explains the best way to write the minutes. And we'll have a link to that in that primer that you'll get. And it shows you an actual example of what a good condo HOA minute report should look like. So that covers my educational session. We hope this helps you, number one, reach your full potential as a board member, and two, give you some ideas of how to run your board meetings effectively, and three, to know where to go for questions you may have related to condo management. So at this point, I'm going to turn it over to Steve, and he's going to lead you through your board certification course.
Thank you, Dan. Appreciate that. And, Dan made some really great points, particularly about how to run an effective board meeting. Dan's going to be available on a consulting basis if you ever need him to run a meeting for you. But let me go ahead and put the presentation up here, get started. Just to give you a little background on the firm and myself. I'm with as Dan mentioned, I'm a shareholder with the Rosenbaum law firm. I've been practicing law now in Florida for almost 30 years, representing condominiums, homeowners associations. I was a in-house counsel for a major real estate developer for about 5 years, and sat on developer controlled boards, had a CAM license at one point, and qualified a condominium hotel. So have a lot of various different experiences, including, I understand as board members, the chairs that you sit in and the things that you have to deal with, as well as managers. So we like to say that we have a deep bench of experience here at Rosenbaum, and we try to offer everybody that we represent practical advice and not just recite the law. With me today is Katie Phillips. Katie is our Director of Education, and she will be trying to address some of your questions in the Q&A, as well as bringing your questions to my attention as we go through the presentation. As Dan suggested, this is a high-level overview of what board members need to be aware of. There are certain topics we're going to address that are going to be just scratching the surface. There's courses that we offer that get into more granular detail on some of these topics, but today's goal is to just raise your level of awareness as to the various different things that you as board members need to be aware of, and some of the basics of Florida law for condominium associations. So let's go ahead and get into that. And let me get this off my screen so I can see what I'm doing here. Okay, so as board members, there's a couple different ways that you can end up on the board. You can either, if you're the developer, if you're a new community, the developer is going to appoint the board until developer turns over control. Once control is transitioned to the members, then the association conducts its first election. Once members are elected to the board by the membership, if a vacancy occurs, typically the remaining directors are going to fill that vacancy. Once that person has been selected to fill a vacancy, they will normally fill the seat that was vacant for the unexpired term of the position. So, for example, if your condominium association has a multi-term seat, if, for example, board members serve for 2 years, now the Condominium Act allows even for longer than that. You can even have a 3-year term at this point. Then, unless your community documents provide otherwise, the vacancy will be the member will serve for the unexpired term of that seat. Okay. The Florida Condominium Act has certain eligibility requirements to serve on the board. Those include not being convicted of a felony within 5 years prior to your last date of eligibility to run for the board, and having your civil rights restored. So if you've been convicted of a felony and it's more than 5 years ago, but you have not had all your civil rights restored, you may not be eligible to serve on your condominium board. You'll have to look into that. The Department of Business and Professional Regulation has changed its position with regard to your right to bear arms, whether you need that right restored in order to be eligible to serve on a condominium board. Initially, they said yes. Now they say no. That issue has not been decided by a court of law, so that's kind of up in the air. Also, if you've been removed or suspended by the Department of Business and Professional Regulation, then you wouldn't be eligible to serve on your board. Co-owners may serve on the board if they own more than one unit, or if there are not enough eligible members running for the board to fill all the vacancies on the board at that time. Now, when we talk about the size of a board of directors, that is typically driven by your bylaws or your articles of incorporation. And, just to take a moment here to talk about the hierarchy of your governing documents. First, we look at the Florida Condominium Act. In some instances, depending on how old your condominium is, there may be a certain year that your documents were recorded and they may not incorporate future amendments to the Condominium Act, in which case we have to go back and look at the statute as it was when your community was created. If your documents incorporate future amendments to the Condominium Act, then we go by the current law. After we look at Florida law, then we look at your declaration of condominium. The law views your declaration of condominium as like your community's constitution. That's the paramount document that governs the relationship between the association and the members. And then we have our articles of incorporation, which created your association, which is a business entity that is filed with the Department of State Division of Corporations. And I'm sure if you don't know, you'll find out that every year you have to file an annual business report updating the officers and directors following an election with the state. And then we come to your bylaws. Your bylaws are going to be the document that you refer to for how you call meetings, how much notice you may need to provide directors of a meeting. Statute governs a lot of this, but sometimes the statute will say, unless your documents provide otherwise. So it's important to understand what the bylaws say. For example, Dan mentioned having agendas for your board meetings. You may have a specific template that your notices have to contain an agenda for. So your bylaws may lay out the basic template for your agendas. Also, the procedure for holding elections may be in your bylaws. With condominiums, we usually follow the Condominium Act for elections, but we'll see, how many, whether you have a staggered board, for example, it may not be that all your seats come up for election every year. When your annual meetings are to be conducted are going to be governed by your bylaws. I've seen bylaws that actually specify a specific date and time that you're supposed to hold your annual meeting. Things like that will be in your bylaws. And then after your bylaws, we come to rules and regulations. And those are things that the board implements to complement these documents that we just talked about, the declaration, articles, and bylaws. The board cannot adopt rules and regulations that conflict with specific rights that are granted to the membership in these other documents. So it's important you understand and read through your governing documents, even though you're taking this class, so that you understand what rights and restrictions the members have with regard to the condominium. Okay, so now getting back to the size of the board, your bylaws or your articles will typically fix the size of the board. If they don't, the default under Florida law is 5 director seats. And unless your association is of a certain size, in which case you can operate with 3. Okay. As far as a cap on the size of the board, there's no specific cap, but bear in mind that the larger the board is, perhaps the more difficult it is to manage your association. Okay, so let's talk about elections for a bit here and how the election process works. Condominium Act requires that a notice of annual meeting, a first notice of annual meeting, be sent out at least 60 days prior to when your annual meeting is to be held. I've noticed recently that there's been some calculation errors that have been made by folks when they're preparing their notices. So when you're doing your notices and calculating these deadlines, you're working backwards from the date that you're going to be holding your annual meeting. So for example, if my annual meeting is March 15th, I'm going to calculate backwards from the 15th of March, 60 days to know when I have to send out that first notice, not moving forward, because you're going to be off by a day. And the next deadline that comes into play here is the notice of intent that candidates must submit to the association to declare their candidacy to run for the board. That has to be submitted to the association not less than 40 days prior to the election. And if that day happens to fall on a weekend, then that's the day.
So speaking of that, Steve, so if the bylaws say that the meeting has to be on a specific day, can the board change that, or does that have to be the community to change that?
Yeah, so any change that you're going to make to the bylaws would have to be a membership vote, and you'd have to satisfy the membership, the voting threshold in your bylaws. And in some cases, that for condominiums, I've seen that threshold to be very high, can be 75, 80%. Sometimes it's a majority if it's been modified. But the bylaws have to be amended by a membership vote. And I do recommend that if you do have bylaws that call for a specific date, that you do try and change that. Obviously, if you miss the day for good reason, whether you're going to be subject to disciplinary action by the department is, it is a violation of the statute not to hold your meeting on the day that the bylaws call for. But certainly there's scenarios that come up where there's mitigating factors where, for example, a second notice went out that's defective. The rules governing elections require you to fix something that went wrong during the election process before the election is actually held, if you become aware of that problem before the election is held. So if something like that happens, you want to reach out to your association counsel, get advice on how to proceed, so you as a board are not making that decision. And then if there is a situation where, legal counsel says, the process is run awry, you need to fix the process to avoid a legal challenge. I often get the question, well, does the board have to approve that? Well, that comes back to something Dan mentioned earlier, which is that fiduciary duty. We have a duty as board members to adhere to the law. So it's not, some of these things aren't necessarily optional or require a board vote to proceed. But again, rely on your association's legal counsel for that advice, so the board isn't making, that decision in a vacuum. After the 40-day deadline to submit notices of intent, the statute provides another 5 days for the candidates who have declared to submit a candidate information sheet. And that information sheet is supposed to be 1 page, 8.5 by 11. The candidate can say whatever they want on that piece of paper. Sometimes what they say is not flattering. It may even be inaccurate. It could be false. Sometimes I've had members of the board consider it to be defamatory. The law requires that the association send out that candidate information sheet with the second notice of annual meeting, whether we like what it says or not, whether it's true or not. The statute does contain a provision that absolves the board from the association, I should say, of any liability related to the contents of a candidate information sheet. If we don't mail out timely submitted candidate information sheets with the second notice of annual meeting, the administrative rules say that that's a defective second notice. The election is subject to challenge, and the division will order a new election to be held. So if something like that happens inadvertently, we're going to want to fix that as soon as that comes to our attention, if it does before the election has actually been held.
Steve, can the candidate form be emailed back in, or does
Yes.
that have to be? It can be.
Yeah, a candidate information sheet can be returned to the association
And then
by
it's to
email.
run.
Yeah, and the
Yeah.
intent to run, right? As long as you're able to, verify it came from the candidate, if we know it's from the candidate, unless we have a reason to believe it's not, it should be accepted, and it should be delivered with the second notice.
And then really quickly, if the bylaws say that they need to have not less than 3, but no more than 7,
Mhm.
do they have to allow all the way up to 7, or can they, if they've had 5 only on the board, can they say it's only 5?
Yeah, so the question is, if the bylaws give you a range of seats on the board, anywhere from 3 to 7, and the board has been operating with 5 directors, do we have to go to 7? The short answer is, I would say no. The long answer is it depends on what the bylaws say. If the board can decide the number of seats on the board at any given time, then if a particular board decides to increase the number of seats from 5 to 7, then that would be okay. If it requires a membership vote to do that, then that would have to be done, at the annual meeting for the next election cycle. And if you are going to increase the size of the board, it has to be done sufficiently in advance of the annual meeting so that you can meet these deadlines and give the membership the opportunity to vote for those additional seats on the board that you've opened up. Similarly, you can move backwards if that's a board decision, if you want to go from 5 to 3, if you have that flexibility, if the documents give the board that authority. Once we have the candidate information sheets, the second notice of annual meeting can then be mailed to the membership. The statute was recently changed to say that second notice can't go out any sooner than 34 days prior to the annual meeting, but it must go out at least 14 days prior to the annual meeting. So the message there is we got to have those candidate information sheets before that second notice goes out. But once you have them, that second notice can go out the next day. Oftentimes we hear complaints that members aren't getting the second notice quickly enough in time to return their ballots in time for the election because they live out of state, they live in Canada, they live overseas. I mean, at the end of the day, ultimately, it's the owner's responsibility to get their ballot back to the association timely. But, if the association is able to mail out that notice as soon as 34 days after, then that's perfectly appropriate to do. So the only time we actually need to hold an election is if we have more candidates than there are vacant seats on the board eligible for election. So if I have 5 seats up on the board and I only received 4 notices of intent to run timely, then I don't need to have an election. My second notice is going to say, these are the folks who timely returned their notices of intent. They're automatically seated on the board, and that'll be announced at the annual meeting. And then those 4 people, hopefully, if they can agree, will appoint a 5th person to serve in that seat. You cannot operate with an even number of directors because you can have tie votes and resulting in deadlock. If you're in a scenario where the members of the board can't agree on filling a vacancy, then the way you have to handle that is hold a special election and follow the same procedures that we just talked about and have the membership vote to fill that seat. If you can't get any volunteers to fill that seat, well, then, that is a bit of a problem. And, hopefully, you can reach out to somebody in the community and ask them to volunteer so that you don't run into this problem. All right. We talked about the second notice going out at least 14 days prior to the election. What gets included with that second notice? Well, we talked about the candidate information sheets, but you also then must include a ballot. You have to include a outer envelope, which includes the identifying information of the member. So, for example, we have to have a sufficient space and lines for the member to indicate their name, their unit address, their local address, and a place for them to sign the outer envelope of the return envelope. I often get questions if the unit is owned by more than one person, do I need to have multiple signatures on the outer envelope? And so that gets a little bit detailed, and you're going to have to look at your documents to see whether or not you're supposed to have voting certificates identifying who the designated voter is for the unit, whether you've been enforcing a voting certificate requirement. So those are the kinds of things that you're going to need to consult legal counsel about. And you may even want legal counsel at the annual meeting to assist with the election process and making sure that the statute is followed in verifying your envelopes and counting the ballots and properly disqualifying ballots, which we're going to talk about here in a second. So we have that outer envelope. We have to have a second envelope for the secret ballot because we're voting in condo elections by secret ballot. The ballot is not supposed to have anywhere on there for the member to sign the ballot. There's no requirement for signing the ballot. It's only that outer envelope. The smaller secret ballot envelope is going to go in that outer envelope. The owner is going to fill out the envelope and return it to the association. Now, oftentimes what gets a bit confusing is there's going to be a proxy that's included also typically with the second notice package. And that proxy is to establish a quorum for the meeting to conduct any other business that the membership may need to conduct. Well, what would that be, Steve? Well, for example, you may have an amendment on your documents that you want the membership to vote on. So you may include in the annual meeting package a limited proxy for the purpose of voting on an amendment. And so to do that, we're going to need a quorum. And that quorum requirement could be very different from what we need to hold a valid election. To hold an election, we only need 20% of the membership to participate in the election process. So if I have 100 units in my condominium association, I only need 20 unit owners to vote in order to elect the board. And that may sound surprising to some of you, but for those of us who are, who have been dealing with this for years, we know that sometimes there are communities where there's apathy, there's not a lot of participation. And so the legislature has had to, lower the bar, so to speak, in order to facilitate elections as opposed to just rolling over year after year the same people.
Steve, if there's no volunteers to run for the board, can two people from the same unit then be on the board in the condo?
Yes. So if I don't have enough people running for the seats available, then a co-owner or a spouse of an owner, assuming, they're an owner, or if the documents allow a spouse of an owner who's not an owner to run, that would be appropriate. Okay.
We really do try to encourage you to drum up somebody else.
Yeah.
Just because for, optics, it doesn't,
Right.
it's not always the best thing.
Right. To avoid the appearance of, impropriety, you want to get, it's preferred you get somebody else than a co-owner, unless, of course, as I said before, if you own multiple units, then you have a right to have more than one person from the same household on the board. Okay. We talked about how to complete the envelope process here. And signing the outer envelope. Now, one important thing we need to know, what you need to have set up, and Campbell does a really great job of this, is having a ballot box, securing the envelopes that come back in. We're not supposed to validate the outer envelopes until when the annual meeting is actually to be held. And it's supposed to occur at the meeting, or if you're a large community, for example, we have a election coming up next week where there's over 800 units in the condominium, and they get at least 50%, if not more, participation. So the administrative rules allow you to set a meeting the day of the annual meeting. So if my meeting is going to be at 7 o'clock at night, I can hold a meeting earlier that day with the volunteer election counters that you're going to have, and verify the outer envelopes at that earlier meeting. That meeting has to be noticed 48 hours in advance so that anybody who wants to watch that envelope validation process can, any of the members can attend. And you can do that up front so that at the actual annual meeting, that counting process and opening those envelopes and getting those ballots out can go faster.
So Steve, can they email notice of the meeting package?
Yeah, so when it comes to emailing notice of the annual meeting package, you can do that as a courtesy, okay, but you still have to send it by snail mail unless you have folks who have signed up with the association formally in writing to receive notices from the association by electronic mail in lieu of US mail. If you don't have that on file, then you can't substitute electronic mail for US mail. So, and, eventually, I would expect the trend to be to mandate electronic transmission, but we're just not there yet. Not everybody has, may have access to the internet. And then, of course, in our older communities where folks may not be able to operate a computer, they still want to have the ability to vote. So, we haven't made the complete switch over to electronic mail. Now, when we talk about disqualifying ballots, again, this is something that you should work at least with your manager at the meeting, if not with legal counsel at the annual meeting, to make sure that if you're going to disqualify any envelopes, it's being done properly. So, for example, if the outer envelope doesn't have the identifying information on it, you can't match the name on the outer envelope to your membership roster. We go a step further and check the property appraisal records to see if there was a sale in between when the first notice went out and the actual annual meeting date. You can't match the name on the outer envelope with the membership records or property appraiser records, we're going to disqualify that envelope. Another basis for disqualification is if you have more than one ballot in the return envelope from one unit, that's going to be a grounds for disqualification. If we get more than one return envelope from an owner, that's going to be grounds for disqualification. You only get one vote per unit. If you own multiple units, you get to vote for the number of units that you own. Once I open up those ballots, if somebody voted for more candidates, then there are seats up for election. So if I have 3 seats up and somebody voted for 4 candidates, that ballot's going to be disqualified. If I can't tell who the person voted for because they've crossed it out too many times or they just didn't mark the ballot clearly, that could be grounds for disqualification. So again, there are a couple of different reasons why we may disqualify a ballot. When we do that, we mark the ballot. We usually write the reason for disqualification on the ballot. And when we announce the results at the end of the meeting, we also indicate the number of ballots disqualified. Typically, more often than not, the number of ballots disqualified didn't end up having wouldn't have had necessarily an impact on the outcome of the election. But there are times where you have election results that are within one vote, and it may end up that you have an election challenge by one of the candidates, and that's just something that is par for the course and you have to deal with. Now, when we talk about other documents that can be included in the inner envelope, sometimes we get back a proxy that's in the ballot envelope. That can be separated from the ballot and without destroying anonymity. We've had scenarios where the person has wrote their name on the ballot. The division takes the position now that if an owner wishes to waive secrecy, that's their right and they can do so, and you should still count the ballot. Now, as we talked about before a little bit, if the election process is not followed, the election is subject to challenge. The time frame for an election challenge to be brought is 60 days after the election results have been announced. So if somebody is going to challenge that process, they have to give notice to the association in advance. They have to give the association the opportunity to cure whatever defect they claim occurred during the election process. If such a notice is received by the board, I strongly recommend you get your legal counsel involved right away so you can get guidance on how to proceed. The legislature amended the statute, the Condominium Act in 2021 to allow election challenges either to go to arbitration or to straight to state court. So it depends on which direction you want to travel. Sometimes the challenger will file an arbitration because those cases tend to move along quicker than in state court. And then there may be reasons why as an association you prefer to be in state court on an election challenge. Now, after your annual meeting, typically the same night, immediately following the annual meeting, you'll hold an organizational meeting of the board. And so that is when the board elects officers of the board at that time. And so you're going to want to elect at a minimum a president, vice president, secretary, and treasurer. And this is the only time when directors can vote by secret ballot, whether it's it doesn't have to be anything formal. It can be possibly by sticky, but at the end of the day, that's the only time directors can vote in secrecy. And electing officers should happen in front of the membership. It's not something that we go off into a separate room and do on our own. If the directors are not in a position to decide who the officers are going to be the night of the annual meeting, because you haven't had a chance to really talk about it, the organizational meeting can take place up to 10 days after the annual meeting by law. So while it's typically held that night, for continuity of governance, it doesn't have to happen that night. And management, if you have a management company, can help you work through those issues as well as your legal counsel. Okay. Now, when we talk about board member roles and we talk about the president and the role of the president, well, much like any other corporation, the president is chief executive officer of the corporation, and they're discharged with the duties of operating your business, your corporation, on a day-to-day basis. Also, the president typically signs contracts on behalf of the association and other legal documents. Now, does that translate into the president can sign contracts on behalf of the association without the board approving it? Typically, the answer is no. I mean, unless there's an emergency, any contract that's going to come that the association wants to enter into should be discussed at a duly noticed board meeting and should be approved by at least a majority of a quorum of the board. Question?
Really quickly, there's a couple questions back under elections. Sorry
Sure.
about that.
That's okay.
Can candidates send out to the unit owners, campaign information
Right.
about themselves? Can they
Yes.
go
So,
to owners and campaign for themselves?
so the question is can candidates campaign with the membership during the election cycle? And the answer is yes. And sometimes that process gets very heated. But it's appropriate for there's nothing wrong with a candidate trying to lobby the membership to vote for them. Some communities hold a candidate information night in order to control, to bring a little bit of order to that process rather than emails flying in the building back and forth between the candidates, and we've seen that get out of hand. So it may be you want to hold a formal candidate information night where candidates can introduce themselves and speak for however many minutes and take a Q&A session. Everybody, if you're going to do that, it should be done in a fashion where everybody who's candidates is treated fairly and they get the same amount of time, et cetera, and then have a set time for that meeting so that once you reach, in advance, people know, okay, this meeting is going to be an hour long, 2 hours long, whatever it is that you set aside for it.
And if you submitted your candidate intent to run form with your nickname, so you're Steve, but your legal name is Steven,
Right.
can you be disqualified for that, or do you need to amend your intent to run form?
Yeah, I don't think, the legal name should appear on the ballot. If somebody goes by their nickname, I think we know who they are. And I think if we use that as a basis for disqualifying a candidate, that that might involve, trigger a legal challenge. It wouldn't hurt to ask the person to, add their full name to the candidate information sheet just for the association's records, but I don't think that renders the intent untimely. The other thing we should just briefly touch on is if you're delinquent on your assessments at the last date when your candidate, your notice of intent form is due to be eligible to run for the board, that's also going to take you out of eligibility. So you have to be current on the payment of your assessments to be eligible to run for the board.
Thank you.
Sure. So in addition to the president, we talked about the vice president. Again, vice president's role is to step in when the president is unavailable, and then whatever duties that either the president or the board may delegate to the vice president. In communities where we have larger boards, there may be more than one vice president, and that's perfectly fine. Sometimes the vice president will chair committees, such as if you have an art committee. More often than not, depending on each member's life experiences, may dictate what roles they serve on committees. And then we have the secretary. The secretary is responsible for keeping and maintaining the books and records of the association. If you have a professional management company, that job is typically delegated to the management company, and so therefore the secretary's responsibility would be making sure management is doing their job and keeping and maintaining the books and records. Secretary also keeps the minutes of the meeting, unless the manager is doing so. We have communities that also have an assistant secretary. And aside from the president, vice president, secretary, and treasurer, your bylaws may say you can have assistant officers who don't need to be board members, again, depending on the complexity and size of your community. So
If a board member, or not a board member, if someone runs for the board and their unit is listed for sale, are they still eligible to run?
yeah, technically, so long if somebody's unit is listed for sale and they put in their name to be a candidate for the board, are they eligible to run? So until such time as the transaction closes, that person is eligible to run for the board. If we see that creating a problem, it's certainly something you can talk to the person about, but the fact that they've put in their notice of intent anyway, suggests that, I'm not sure what the motivation would be. But until such time as the transaction closes, they're considered a member and eligible to run. Once that transaction closes and the unit transfers, that person's deemed to be automatically either not eligible at that point or off the board if the election happened prior to closing. And this has happened in other scenarios as well, where somebody has put in a notice of intent, the second notice and ballot has gone out to the membership. One of the candidates has resigned, has put in a notice saying they withdraw their candidacy. That doesn't mean that we then send out a new notice, change the meeting date, and provide a new ballot to the membership. The best way to handle that is, communicate to the membership in whatever means you have available, e-blast, and notify the membership that somebody's withdrawn their candidacy on the night of the annual meeting. We're just not going to count those votes. And whoever gets the next highest votes would be the winner. Unfortunately, that's the best way you can manage that problem. Now, talking about the role of the treasurer on your board, the treasurer is, as it sounds, the custodian of the funds of the association. I guess, again, unless that duty has been delegated to management. Typically, your treasurer, along with the president, are going to be the two officers responsible for approving the payment of invoices to your vendors and contractors, which, again, if you have professional management, is going to be done electronically. And the treasurer is going to typically provide the financial report to the board and members at board meetings, however frequently that the board meets. And this is certainly something, when we talk about transparency, as Dan mentioned, this is an important area where you want to keep your membership informed. How much money do you have on hand? How much money do you have in reserves? Do we have sufficient amount of cash on hand to meet expenses? Do we see ourselves, getting short? Could there be the need for a special assessment as the year progresses? Where are we over budget? Where are we under budget? Those are all the kind of things that we want to be communicating at board meetings. Also, the treasurer is responsible for coordinating and developing the annual budget and making sure that the annual financial report is done on a timely basis. And depending on your condominium association, that may be an audited financial statements if you meet that threshold, which we'll talk about in a little bit. And that's about all of what the treasurer is supposed to do. What the treasurer isn't able to do is bind the association or the board of directors when dealing with third parties. And that's true of all of the officers, with the exception, well, even with the president. If the president doesn't have the authority from the board to bind the association and enters into a contract, you may have an issue there and you need to talk to your association legal counsel. But, I want to emphasize, unless you have an emergency, contracts should be brought to the board for approval. You may even want legal counsel, depending on the amount of the contractual commitment, to review that contract. If it's a contract with a professional, such as an engineer, you may want that contract reviewed by legal counsel just to make sure that there aren't provisions in there that are detrimental to the association in the event that the relationship goes the wrong way down the road. When we talk about committees, your bylaws are going to establish who has the authority to appoint committees, whether it's vested with the president or if it's the board. And, I strongly recommend, when you're forming committees, that the board have a clear picture as to what the true needs are of the association or the board, what role the board wants the committee to serve, and have a clear understanding of that with whoever you appoint to those committees, so you're not finding yourselves months down the road in a position where the committee isn't performing or isn't pursuing the objectives of the board as it was envisioned, and then the board's put in the uncomfortable position of having to either disband the committee, remove members from the committee, remove the chair that was appointed to the committee. These are all things that get very uncomfortable, and we want to try and avoid them to the extent possible. So now, the two types of committee, if you have a committee that has spending authority, that's been delegated spending authority, those committees have to be noticed and conducted the same way as board meetings. Similarly, if you have an ARC committee for your condominium association, that committee should meet with the same formalities as the board. Unfortunately, the Condominium Act, the way it's drafted, says unless your bylaws exempt other committees from having to adhere to the notice requirements, that those committees also have to be open to the membership. So that's something you may want to look at because, for example, the fining committee, if you have a fining committee, you may not want that committee meeting open to the membership because it may make the folks that have to be on that committee uncomfortable because obviously they're put in the role of having to enforce the rules and regulations of the association and levy fines on their neighbors, and that may not be something that y'all want open to the membership at large. So if for those folks who don't elect to do a board certification class, this is the form that the state promulgates that you have to sign in lieu of taking a course. We strongly recommend taking the course, even if you've signed one of these forms already. Those of you here today, we tip our hat to you for attending the board cert class because there is so much to learn, and just reading your documents in and of itself is really not going to do it. So this is just a recap of some of the things and responsibilities that board members have to deal with: establishing sound fiscal policies and maintaining accurate records, enforcing the documents. That's critically important that we enforce our documents in a uniform and consistent manner, because if we don't do that, we run into situations where in a scenario where we want to be able to enforce our documents, we can't because of either past selective enforcement. Talk to your legal counsel. If there's been past selective enforcement by prior boards, there's ways to fix that. And your legal counsel can walk you through those steps. Develop a workable budget, keeping in mind the requirements and expectations of the community. Establish reserve funds. That's been a topic of discussion over the past year since the legislature, passed SB 4 in response to Champlain Towers. We're looking for some clarification on some of those new laws coming into the next legislative session, which is going to start momentarily. But reserves, as Dan mentioned, kicking the can down the road is not the right approach. We want to have reserve funds. We want to make sure that we're funding reserves at the full levels that we need to be funding. Having a reserve study done at least every 3 years. This is something that was taken out of the statute for some reason, which used to require condominiums to conduct reserve studies every 3 years. It's still a good and best practice, and it's something that we recommend you do. Establish, publicize, and enforce your rules and penalties. Authorize legal action against owners who don't comply with those rules, and so on and so forth.
And we're gonna give everyone a copy of these slides so that they'll be able to review all those items. And I'm getting a lot of questions about the certificates. Sorry to interject.
Sure,
Steve,
go ahead.
We do use a third-party company that exports all the information from Zoom. So everything that you put in with your name and your email address, you will get a certificate from me if you've attended this entire presentation. And don't worry about that. And if you don't get it, just check your spam folder, but that will all be explained in an email. Okay.
All right, so moving on, these next couple slides talk about what the Florida Supreme Court considers to be the unauthorized practice of law, and gives you a guide as board members so that you know upfront what your managers can and cannot do. So when your managers tell you need to get your legal counsel to do that, it's not because they're trying to avoid doing a task. It's because they don't want to put their license in jeopardy. So these are things that managers can't do because it's considered the unlicensed practice of law. And then there are things that managers can do, which include, drafting a first or second notice for the election, issuing estoppel certificates, preparing the ballot, and some of these other things. Once a manager starts having to review the documents and tell you what they mean, now you're getting into a legal opinion. And so that's something that has to go to legal counsel. Okay. Which we talked about. So now one thing to keep in mind, once you are on the board, it's important to keep your assessments current. If you go more than 90 days delinquent, and this has been changed not to any monetary obligation, but just your assessments. So this would not include fines. Then you're automatically deemed to abandon your position on the board. So this is one of those rare exceptions too, in order to be removed from the board, that a membership vote has to take place, which we could refer to as a recall. This by statute and by operational law is automatic. Okay. So unless otherwise provided in your bylaws, the officers and board members serve without compensation. I'm sure that doesn't come as a surprise to anybody here on the call today. Dan briefly touched on the fiduciary relationship as directors that you have with the membership. So the law imposes on every board member a fiduciary duty with the members of the association. As directors, we hold a position of trust. And so we have to act in good faith on behalf of the association and using our sound business judgment in making decisions. So what does that mean? Well, it means, number one, we don't want to act in reckless disregard for the safety of the membership or the property of the association. So when we talk about preserving the assets of the community, that's an important duty of the board. Whether it's, the swimming pool, tennis courts, whatever the case may be, it's important to maintain the condominium property. Then it's also, we have a fiduciary duty to enforce the documents on a consistent and uniform basis. And then relying on the professional advice of your professionals is extremely important in discharging your fiduciary duty. So if you're dealing with a construction issue, for example, you're going to have a balcony restoration project. It's important to consult with an engineer for that project. You don't want to just hire a contractor to do major restoration work on your building without having a consulting engineer. That would not be a good idea. And then other issues that may come up. If you have a safety issue in the building, you may need to involve a safety expert. It really depends. And that's where, your legal counsel can also offer you guidance and advice. Briefly here, just to touch on a few no-nos as to officers and directors and managers. It's prohibited by statute to solicit, offer, to accept, or accept anything of value for which consideration has not been provided for either your personal benefit or your immediate family. That's going to be considered, what we call a kickback in layman's terms, and a violation of the statute that could get you removed from office by the department if it's reported. And so forth. The one exception to this rule has to do with accepting items at a trade show for educational purposes. That's exempt by statute. So next thing we're going to talk about here is, unless we have questions on what we've covered so far, is bidding out contracts and what the statute requires, and then what's also, best practice.
Yeah, I think we can, we have some questions, but they're not, we can talk about them.
Okay, as we go. Okay, so when we talk about bidding contracts, the statute requires that the association obtain bids on any contract that exceeds 5% of the association's total budget, which includes reserves. So when you're trying to figure out if you have to bid a contract, that's your formula. Now, if there's a contract that's less than that mandatory threshold, should we obtain bids anyway? Well, depending on what it is, it's usually a best practice to at least get 2 bids. There's no statutory requirement that you get 3 bids, though that tends to be the industry standard. 2 bids are acceptable. I'm hearing from clients, depending on what the area is, that they can't get 3 bids because, reserve specialists are so busy right now, engineers are tied up, so forth and so on. So if you can't get the bids, you can't get them. Certain professionals are exempt, and we've listed them here, which include attorneys, accountants, architects, professional management companies, engineering firms. So if you're not sure whether you have to obtain a bid for a certain professional, just again, consult legal counsel.
Can a board member offer services to owners for compensation? So I'm guessing that means like if a board member does hurricane shutters, can
Right.
they offer those services?
Yeah, so if a board member wants to offer services to unit owners, that's different than the association entering into a contract with a company that the board member owns. Okay, and there is a process to follow to go through that, to do that. I don't recommend it, but it is something that can be done if there's a proper process followed. But a board member, providing services to an owner, it doesn't violate the statute. On the other hand, the problem you run into is what hat was the board member wearing when they did that, and then if something goes wrong, that the owner tries to attribute that back to the association. So there is a liability concern there. It's preferred that you not do that. But if something like that's going to happen, it may be appropriate to document it in a certain way. And again, that's something to talk about with your individual association counsel as to how best to manage any potential exposure that you'd have there. Let me just back up a slide. So maintenance and management contracts must specifically identify the services, the obligations, and the responsibility of the contracting parties. They must specify the cost of the service, frequency of performance, minimum of persons who will be employed. The agreement must disclose any relationship that the manager or contractor has if it's with the developer who's currently in control of the association. Most of you probably don't fall into that category, but there are certain mandatory requirements for contracts. One of the things we always look at as legal counsel is there an indemnity clause in the contract? Is it disfavorable to the association? Does the association have a clause in the contract to terminate for convenience? These are all important things that you don't want to leave to chance. And as a board, you don't want to be making those decisions on your own. Contracts that are made by the developer prior to turnover are subject to termination after turnover if a certain voting threshold is satisfied. And that generally covers contracts. With regard to bids, one thing I will point out, and it's probably covered elsewhere in the presentation, is all bids should be retained by the association as an official record, and they should be retained for at least, I believe, 1 year as part of your official records. And if your association is at least 150 units and you have a mandatory website requirement, either those bids or summary of bids are supposed to be kept on your website. Okay. So getting into conflicts of interest a little bit more, this talks about the scenario where if a member of the board owns a business that wants to enter into a contract with the association, this describes the manner in which you have to go through that, including that you need a 2/3 vote of the directors other than the board member who has the financial interest on the other side of that arrangement. Once that is approved in the appropriate fashion, it then has to be disclosed to the membership. The membership at the next meeting, whether it's an annual meeting or a special meeting, have the right to vote to cancel that contract. And if that's how the members vote, regardless of what the contract may say, no termination fee can be charged as a liquidation damage or penalty. So the person would only be entitled, or the company would only be entitled to be compensated for services rendered up to the date of termination by the membership. Again, these are things that we don't recommend if you can avoid them, because it creates the appearance of impropriety and can be used as fodder, at the next election cycle. The Florida Administrative Code addresses violations that the Department of Business and Professional Regulation investigates on behalf of condominiums. So condominiums are heavily regulated by the department, whereas homeowners associations don't have any similar oversight by the department. And so if an owner files a complaint with the department, they have to investigate it. They'll send what's referred to as an allegation letter to the association with the complaint. The association has to respond to that. I strongly recommend, if you get a letter like that or contacted by the department, that you get a hold of your legal counsel so that they can review and address the allegation letter that's been served on the association. And depending on what the outcome of that investigation is, there are certain violations that are either considered minor or major, and there's a whole list of them. in the administrative code, and also the amount of the fine that the department has to levy if they find a violation. It used to be that they had discretion. That's been changed to where it's now mandatory. And the fines are usually based on the number of units in your condominium. And if they're a minor violation, the cap is lower than if it's a major violation. The fines can be as high as $10,000, depending on the frequency of the violation and a number of other factors.
So Steve, do conflicts of interest include working with the contractor doing work on an individual ARC for an individual unit owner?
Say that again.
Yeah, I know. Does conflict of interest include working with a contractor that's doing work for owners, which requires ARC approval? I would think it's anybody doing work. If a board member is related to,
Well, I think
the
that
company.
if the board member is an employee of a company that's been hired by a unit owner
right,
to do work in a unit, I don't see that being a conflict. They're an employee of a business. They're just working, making a living. And
Right.
the issue is, the conflict of interest issue is when I, as a board member, have an ownership interest. I'm an owner of a company that's going to enter into a contract with the association. So in that scenario, that needs to be disclosed by the director and voted on. So for example, I had a situation years ago where one of the board members, he and his family owned a painting company. The condominium was going to paint the building. And he said, hey, listen, my family owns a painting supply company. We can provide the paint to the association at cost. So, it was a good thing. They were going to save money, but you still got to follow that statutory process of having the board approve it with the requisite vote and disclosing it to the membership and giving the membership the opportunity to vote to cancel before you go forward, so that you don't have a problem. And of course, if you're saving money, doesn't sound like you would have a problem. It's just following those steps. So again, if you run into a situation like that, the best thing to do is contact legal counsel, make sure they have all the facts so that they can advise you correctly. And then the board can decide whether to move forward with that type of an arrangement. Okay. All right, so I'm going to move through these lists of violations and move into board meetings. Dan talked about the nuts and bolts of how to conduct an effective board meeting. I'm going to deal with the legal side of it in terms of statutory compliance. And so when we talk about a board meeting, it's any gathering of a quorum of the board to conduct association business. When Dan was talking earlier about dealing with controversial issues and holding meetings and making sure you don't have a quorum, if it's not a properly noticed board meeting, this is what he's talking about here. And that is, if you have a quorum of the board conducting association business, it needs to be noticed at least 48 hours in advance, posted on the condominium property, wherever the board has designated posting notices. If you don't know where that is, then you need to create a place. And that should be reflected in the minutes. If you want to change where or how you post notices, that's something that needs to be done at a meeting and then reflected in the minutes. The board cannot make decisions outside of a duly noticed meeting, except in two circumstances. And that's when we're dealing with legal counsel to discuss threatened litigation or actual litigation that's pending, or if you're dealing with personnel issues. And by personnel issues, I mean actual employees of the association. If you have a professional management company, well, that professional management company is an independent contractor. They're not an employee of the association. And so if you're talking about a situation with your manager, if you have a situation with your manager, that's not something you can do necessarily at a closed meeting. So you're going to have to figure out how to best manage that issue if it's not something you want to do in front of the membership. And again, that may be a question you have to run by counsel.
So Steve, this is a good time. And this is a
Sure.
great question that comes up at almost all of these classes. How can a majority of the board conduct working meetings to conduct research, review documents, gather proposals, estimates, plan meeting agendas, etc., without having to declare and post it as a meeting of the board? Conducting work only by email is inefficient. No other business is so handcuffed. Yeah.
No, I understand. And I sympathize with the person who asked that question. This is where committees can come into play and be helpful, perhaps. There's no easy solution to that. And, depending on what the topics are, if you notice it, there are people just probably aren't going to come to the meetings anyway. It really depends. So, if you're looking, for example, if you're trying to hire new management or new legal counsel or whatever the subject is, new landscape contractor, and you don't want to have a board meeting every time you're going to discuss that issue, you're going to have to delegate it to less than a quorum of the board. And there's just no way, there really is no way around that. I understand that communicating by email is not convenient. And certainly, I don't know that I discussed it directly, but voting by email is not something that really should be going on. And if there are things that have to be approved in advance of a board meeting, that's something that either the manager can handle by polling the board directly, or the president can make some phone calls and make sure that everybody's on board, or at least the majority of the board is on board with the process that you're going forward with. But unfortunately, there's no easy answers there. So now,
and then quickly at the monthly meetings, this is a couple people have asked, as I tried to kind of answer this, monthly expense approvals. So, when you have to do that, does that have to be done at a board meeting?
yeah, so monthly expense approvals. So if there's certain things that you don't want to have to approve at every board meeting that are recurring expenses that are below a certain threshold, one of the things that we recommend for our clients is just, adopt a written resolution that delegates a certain amount of spending authority to management or the president of the association, or maybe it's the president with the approval of the treasurer. However it makes sense, and whatever your comfort level is as a community, and every community is different, you can delegate spending authority. Some management agreements that I read have a delegated spending authority to management, particularly in the event of an emergency. And, let me be clear, when we're talking about everything today, we're talking about normal operating procedures. We're not talking about when we're in a crisis mode because we have a state of emergency because there's a hurricane that hit and we're having to deal with, a disaster cleanup. There's a different set of rules for that.
Well, and I think it's really important to mention, Steve, that all contracts, regular recurring monthly contracts and special contracts for construction, but all contracts need to be approved by the board.
All contracts need to be approved by the board. If we're talking about a minor maintenance repair, the plumber needs to come out to the condominium to, check a pipe. I mean, those are the kind of things that we're talking about where as an operational thing and the cost is so low that I think falls into the purview of the president or management. But if we're talking about signing a piece of paper where we have terms and conditions, we've received a formal written proposal, that's the kind of thing that needs to be approved at a board meeting. And I can't tell you how many times I've seen proposals that come from vendors that just don't have what they need to have in there for the association, especially condominium associations, insurance requirements. I mean, I could go on. So it's really important that you as a board establish what's our tolerance, what's our risk tolerance in terms of dollars before we spend the money with legal counsel. Because it's the old adage, penny wise and pound foolish. We save a few dollars and it costs us thousands down the road in litigation. It's better to spend the money up front and try to mitigate, issues down the road.
Yeah, and
Something
those
else you wanna-
contracts that are above it, the normal budgeting things, so concrete restoration,
Oh, yeah.
roofing, all of those things that require a special assessment, that is a separate notice.
Yeah, well, we're going to talk about
Yeah,
special
no,
assessments
Steve will
next.
get- I was just gonna say, Steve is gonna get into that.
It's the next slide. So, when we talk about other types of notices that we have to give the membership, when we're dealing with a special assessment, we have to give more notice to the members, and it's got to be mailed, not just posted. So if we are considering a special assessment to fund a project, whether it's a renovation project, capital improvement project, whatever it is, we have to give at least 14 days notice of that meeting. And if it is a special assessment, the notice has to be very clear. A special assessment is going to be considered, what the estimated cost of the project is, the purpose of the assessment. If you're in a condominium where you're your assessments are assessed on a percentage basis rather than a per unit basis. We typically want to see a schedule of unit type, what the proposed assessment amount is going to be for that unit type, and all those things. And I've even seen documents where it says the board, in levying a special assessment, must adopt a resolution. Well, to me, that's more than just a simple motion. That means I need to have an actual written resolution for that special assessment. I'd rather have legal counsel prepare that resolution rather than get into a legal dispute with one owner over what that word resolution means. It's a lot cheaper to just prepare the resolution. So always check when you're looking to do a special assessment what your authority is under your condominium documents. Make sure that the project you're about to undertake is not a material alteration of the condominium property or the common elements that you may need a membership vote to coincide with whatever project you're doing. Dan mentioned pickleball courts. Well, if you're taking a tennis court and you're going to, redo it into 2 pickleball courts, that's going to be a material alteration. We're eliminating a tennis court. We're putting in pickleball. We're going to need a vote of the owners. And depending on what your documents say, that vote may need to be 75%. Sometimes your documents don't have a material alteration provision. We're going to have to go to the statute. Sometimes if you have newer documents, the board may have certain spending authority up to a cap to make material alterations without a membership vote. So these are all things that you have to at least be aware of, or talk to your manager about, and figure out, do we need legal counsel involved so we don't make a misstep and have to spend thousands of dollars to fix a problem. And when it comes to material alterations, the statute was changed a few years back, and you have to get that vote before the alteration occurs. So if the alteration occurs, you didn't get the vote and it's challenged, you're going to have a problem. So it's important to understand and have, understand, do I have this issue? Let's verify whether it is a problem. Is it something we need to address and deal with it up front so that we're not trying to, fix it after the fact.
So this is a good one. This comes up at this time of year.
Yeah.
How do we call a meeting with the board about getting new property management when we don't want the manager
Right.
involved or at the meeting?
Yeah, it's a problem. The
Board
question
noticed
is,
it themselves.
yeah, the board can notice a meeting without the assistance of management. And my guess is that if you're at that point, it's not going to come as a surprise to the management company. And it may be something that you just need to be upfront about. I mean, I'm sure there's been a number of communications that have taken place between the board and management about not meeting expectations before you've gotten to the point where you're conducting a search. So, it's again, or you delegate that to certain officers or directors of the association. And once you have it, you're ready to make a choice, then you hold that meeting and it's one meeting. So, now, board members have a right to attend our meetings, our board meetings, either by phone, electronically. As Dan mentioned, most of our meetings post-COVID have gone to hybrid meetings. Technically, under the current statute, members don't have a right to attend electronically, only board members do. But, again, if you're set up that way properly, it's better to, offer that option and encourage participation rather than, have, the rumors running around as to what's happening or not happening. Inclusion is always the better policy, at least in my opinion. Now, if a member of the board, if you have to have at least a quorum of the board present to conduct business. So if I have a 5-member board, I have to have 3 directors present, and, majority of those board members can make decisions. If I don't have a quorum, I can't hold a meeting. So that's, really something that the president coordinates and makes sure that before you have a meeting, you're going to have a quorum. You're better off canceling the meeting than showing up, having members show up. And, now things happen, people have emergencies. And if that's the case, that's the case. But, if we have a controversial issue coming up and somebody's going to try and defeat a quorum, it's better to know that up front than going, finding out at the meeting. Let's see if you can. Again, members of the board have to be present in some fashion to vote. board members can't vote by proxy. So a director can't say to, Jane Smith, hey, Jane, you've got my vote. You can vote yes on this topic. It doesn't work that way. So if the director can't be there, they can't vote. Now, after the fact, if the board member wants to join in the outcome of the decision, that can be noted at the next meeting and reflected in the minutes that they agreed with the action taken by the board, or they disagreed, if that's the case. Let's see what else we have here. So when we're talking about, voting as directors, we want to, take a voice vote. Sometimes it may be necessary to call a roll on a controversial issue. At the end of the day, as Dan was talking about, minutes are a summary of the board meeting, and they must at a minimum reflect, a motion that was made by a director, a second, and whether or not the motion carried by at least a majority vote. You may want to specify 4-1, 3-2, whatever the case, but the minutes have to reflect motions that were made, seconded, and who they were made by, who they were seconded by. You don't have to identify how directors voted unless the directors, specifically want to do that, but you at least need to, confirm who made a motion in a second. If you abstain from voting, it's effectively a no vote for purposes of the count. And again, the only time you can vote by secret ballot is for officers. We talked about at the beginning of the presentation, Dan talked about members having a right to speak at board meetings. Members by statute have a right to speak on all agenda items. But on the other hand, the board has the right to control how the meeting is conducted and how long the meetings take. So you can have rules that the board adopts upfront, specifying, the frequency, duration, and other things that the statute allows you to regulate. You can have a sign-in sheet for members who wish to speak. If you haven't signed in, you don't get to speak. If you have signed in, you can have them specify what agenda items they wish to speak on. The rule of thumb is 3 minutes per agenda item, unless you have a really long agenda. And then I would suggest that the shortest would be is 2 minutes. And, I've been at meetings where we've had to clock people because it's a very controversial topic. And, at 3 minutes, if they're in mid-sentence, be polite and say, pardon me, need to interrupt, but you've reached your time limit and we need to move on. I've had situations where people ask me, can somebody, delegate their time to somebody else so that person can talk, for 20 minutes. This isn't Congress. And as Dan was alluding to, Robert's rules within reason. So I don't think members can delegate their time to other members in lieu of talking. If somebody has something they want to say, they can say it. Otherwise, that's it. Owners have the right to record meetings. I think it's good practice to ask at the start of a meeting if anybody's recording the meeting, so people in the room know if it's being recorded. Technically, the member who's doing that should speak up and say, I'm recording the meeting. There are rules that the division has implemented about recording a meeting in a way that does not interfere with the conduct of the meeting. So if somebody shows up with a tripod and a camera and a big, light, and they've got it, on the board as if they're in the lights and we're on, that's not reasonable. But you can adopt rules and regulations regarding the manner and recording meetings as well, if you have to. We talked about those issues. We talked about email. Now, typically when we talk about the agendas for board meetings, your bylaws may have a template of what that agenda should look like, but ultimately the agenda is usually set by the president. If there's an item that the board wishes to get on the agenda and the president is refusing to put that item on the agenda, there's usually a mechanism in the bylaws that says if a certain number of directors request an agenda item in writing, it needs to be put on the agenda. Similarly, if the membership submit a petition to the board and 20% of the voting membership sign that petition, the board has to call a meeting to adjust the items identified in the agenda. And it has to be called within 60 days of the petition being served, and at least 14 days notice have to be given of that meeting. And the owners have a right to speak on those agenda items. That doesn't mean the board is obligated to take any action with respect to that item. I would submit that if it's gotten to the point where 20% of your owners have signed a petition, that probably something needs to be done. Otherwise, at the next election cycle, there's probably going to be a change in the board. But, those are the practical aspects of things. Legally, the board's not required to take any action in response other than to hold the meeting and provide the membership with the forum to speak on the agenda item.
Let's talk really quickly about Zoom before you
Yeah.
move into committees. So, board members that are not in town, they can still be present on Zoom or on a conference call to be part of the meeting and vote, correct? And do the members have any right to make the board have Zoom available for them
No.
if they're not there? Yeah.
Yeah, so the statute doesn't mandate that the board provide video conferencing for members to attend board meetings. It's not something you have to do. It's up to the board whether you want to continue to do that. Then the question becomes, well, if we let members attend by Zoom as a courtesy, do we have to allow them to speak on agenda items because they're not physically present? They don't have a right to attend the meeting by video conferencing. We're just doing that as a courtesy. So we're only going to allow people who physically attend the meeting to speak on agenda items. Again, that goes towards inclusion versus not including the membership and what tone the board wants to set. It's not really, legally, you probably could take the position that if you're not physically present at the meeting, you don't have a right to speak on the agenda item. I could easily hear another attorney say, well, if you provided the forum by Zoom, then they should be able to speak on the agenda item. So I think, err on the side of allowing people to speak. I mean, frankly, you have more control over the durational and being able to mute people if they get out of hand on Zoom than if they're there in person. So, there are advantages to the video conferencing platform.
And then if you have Zoom, are owners allowed to record it themselves, and do you have to allow them to record it? And then secondly, if the recording is done by the association, is that a public record?
Yeah. So, as I said before, any owner can record a meeting. So if the person is attending by Zoom and they have some ability to record, they're not going to be able to do it if you're the host through the Zoom platform. But if they want to have an audio recording and they're using their phone to audio record the meeting, that's perfectly fine. If it's the association's practice to record the meetings, then it is an official record. If the sole purpose of recording the meeting is to make sure the accuracy of the minutes, and then once the minutes have been approved, you eliminate the recording. That's, again, I would have a policy in place on that. But otherwise, if you retain the recordings, it's part of the official records of the association, and somebody wants to go back and listen to a recording, then they'd be entitled to do that. I personally don't recommend recording meetings. I think that, keeping the minutes, if you have your professional management company keeping the minutes, that's all that's necessary. Because all you're doing is creating evidence for, potential court proceeding down the road.
The first thing any attorney asks for when they do a subpoena of your records is your minutes.
Right.
So less is more.
Yeah. Yeah. I mean, if you're talking about, for example, you have a broken sidewalk out in front of the building and you're talking about, how it's a dangerous condition and somebody could really get hurt there, and we need to fix that right away. And that's all put in the minutes. And then somebody trips and falls because you didn't replace you didn't repair the sidewalk in a timely fashion. That's going to be used, in a personal injury lawsuit. So, so be mindful of what goes in those minutes. Okay, getting into committees. We talked about this, so I'm not going to spend too much time on this now. Committees are a group of board members, owners, a mix of both. It can be exclusively just owners. It depends just on what the committee's function is. People who are willing to volunteer. Managing a condominium association is a lot of hard work. It requires a lot of effort and time. And so committees may come in handy in helping the board, manage the overall operation. Having a finance committee, we may even want to do something fun like a social committee. So these are all things we need to think of as a board, and how what we want that committee to do, and so forth. Again, check your governing documents as to whether or not all committee meetings have to be noticed. Depending on how old your documents are, it may be that committee meetings have to be noticed. regardless of what type of committee they are. Budget committees meetings where they have decision-making authority have to be noticed, and your art committee meetings, those typically have to be noticed. Other committee meetings, it may be optional. So this just talks, if your committee has to notice its meetings, it's the same process as a board meeting, also keeping minutes, etc. So in terms of retention of minutes of meetings, I think now you have to keep them indefinitely. It used to be 7 years. So there are certain documents now that the legislature has mandated that a condominium association keep indefinitely. If they weren't being kept before, and it would be prospectively. So again, if you have a concern about compliance, talk to your association counsel.
So we don't really go into great detail on the fines committee and the ARC committee because we have
Right.
separate class on those.
Right.
But couple of quick questions just on that. So do you have to allow members to attend the fines committee meetings?
Yeah. So again, that's one of those committees I think that you need to talk to legal counsel and look at your bylaws. It's certainly a committee meeting where you don't want to have members other than the members who are coming before the committee present, because it's a disciplinary hearing basically. But I think the statute says unless your bylaws exempt the committee from the notice requirements, that members have a right to attend. Getting into these next couple of slides talk about minutes, and we've already covered all that. So I'm going to jump ahead.
Hold on, I'm not done that. I'm not done yet.
Oh, okay.
Don't jump ahead too far. So on the fines committee meeting, can anybody, what happens if they can't get 3 independent people who aren't related to the board to sit on the committee?
Yeah, so this is a common question and a common problem, and that is, what if we can't get qualified members to serve on a fining committee? What do we do? And the answer is well, you can't have a fining committee. And I'm not trying to be flippant. It's just the reality. If we can't get people in the community to step up and help the association enforce its rules through fining, then you have other mechanisms of enforcement. And typically those other options are more expensive because they usually involve legal counsel, because management can send a letter out to an owner about a violation. But at the end of the day, if you have somebody who, doesn't respect the rules and refuses to abide by them, then you're looking at having to bring a legal action, getting an injunction from a court to stop the conduct. Or if it's something somebody's refusing to do, such as access to a unit after a casualty loss, and the association needs to be able to get into that unit to make repair, or at least conduct an inspection to see if repairs need to be made, and the person is refusing access, then you're going to need court intervention to ultimately get what you need. A fine isn't necessarily going to get you where you need to be.
We see a lot of those in condos, but I think the ones that you have, if they're serious enough, you should involve your legal counsel anyway, because it's not like an HOA where you've got, the decorations or plants or things like that. These are usually structural issues and other problems where you need to get the attorney involved anyway.
Right. I mean, fining in condominium association land is limited because you cannot lien a unit for outstanding fines once they hit $1,000 or more, like you can in a homeowners association. And they've even eliminated the ability to disqualify somebody from running for the board or serving on the board based on outstanding fines. So it does appear to be a somewhat limited remedy at this point.
And can the association fine if the docs are really old and there's no Kaufman language and docs silent on fining?
I think so if you have an old condominium and you don't have the authority to fine, it's really probably something you should consult your legal counsel. It probably will require an amendment to your bylaws. So we're still talking here about minutes. Okay, so we talked about what the minutes should reflect. Okay, so moving on to unit owner inquiries. Depending on how active your membership is, you may get written communications from your owners. If you get an email from an owner, it's not something you have to by law respond to. There's a difference between what you're legally required to do and practically what's a good idea. But if you are served with a letter from an owner certified mail, then you have a certain amount of time, 30 days, to respond to that owner. And if you don't respond in a timely fashion, then that's something that can be set up as a complaint with the department and subject the association to fines.
Let's just be clear too, this is not a records request.
Right.
That's handled very
Right.
differently.
Right. So we're not talking about a records request. We're talking about somebody who's asking for information about some subject matter
Like,
related
when
to
are you gonna
kind of.
fix the painting, or when are you gonna fix the
Right.
balcony, right?
So, and it may be that it's a legal issue that requires an interpretation of the documents. Somebody may be asking who's responsible to repair the windows and doors in your condominium. And if you respond within the 30-day period saying you've sought the opinion of counsel, then you have up to 60 days to respond to that inquiry. Otherwise, it has to be responded to within 30. Okay. And also, in addition to an administrative complaint, there could be a legal proceeding brought to compel, a response, and then you're paying legal fees and costs for that. So we don't want to let things get that far. Let's address these things head on. Now, we talked about all this stuff here, substantive response. If you are seeking the advice of counsel, you should let them know within 10 days of receiving the advice of what the substantive response is. Okay. So now we're going to talk about official records, which Katie mentioned. Official records are the records that the association is required to keep and maintain per statute. And those retention periods are specified in the statute. Not every record is created equal when we talk about how long you have to keep them. So certain records have to be kept for 7 years. Other records, such as your election records, only have to be kept for 1 year. And so, these are things that are important to understand. I recommend every condominium association have a formal records inspection policy in place. Okay, I strongly recommend that, because this way these requests can be managed in an orderly fashion. Everybody understands the process. Everybody understands if there's going to be costs associated with their request, and so on and so forth, and how to serve those requests. I mean, in the age of, emails, we have complaints from our managers where, they're getting 10 emails a week from one owner requesting to inspect records. Well, you can adopt a policy that requires that only requests made in writing, sent by certified mail, served on your registered agent, which could be your legal counsel, is the only records request that you're going to treat as one you'll respond to.
For condo, I don't think they have to certify.
No, it's got to be certified mail. Yeah. Yeah. I mean, if they make it in writing, you have to respond to it. But if you specify in a policy that it's got to be by certified mail, then it has to be
Okay,
that way.
and on those unit owner inquiries, those need to be by certified mail, or will email suffice? On
Well,
those?
if you don't have a written policy, the way the statute is worded is you got to respond to a written request. If it's served by certified mail and you don't respond to it, then it's presumptive that you willfully fail to respond to the request. But my recollection is you can have a policy in place that requires it to be served in writing. Okay. And not just by emails don't have to be accepted. Okay. Because that's where you get into the abuse is, repetitive emails. Also, you can limit the number of times per year somebody can inspect the same record if it hasn't changed. If somebody wants to see your bank statements for last month, they can't keep asking to see the same thing if the statement hasn't changed. You have to keep, this is an important one. You have to have an adequate number of copies of your governing documents, rules and regulations, and your year-end financial statements available for inspection and copying. That's not something that we should run into trouble with. Okay. The association is also required to have a frequently asked question sheet. This is a form that's mandated by statute. What that FAQ sheet looks like, what questions have to be answered in standard form is specified by statute. If you don't have an FAQ for your condominium association, get with your legal counsel to get one in place. It talks about things like, what are my voting rights? Are there lease restrictions? Are there any pending actions against the association with an exposure of more than $100,000? Certain things like that. So important to have one of those available, and you can use that because oftentimes we get these lender questionnaires from lenders. The condominium associations don't have an obligation to provide information to lenders other than as required by statute. So if you have an FAQ, you can use that in lieu of responding to a mortgage questionnaire. And as we said before, you can adopt these rules and regulations regarding time, location, and notice of records inspections. You have to make records available for inspection within 10 business days of receipt of a written request. That means we should communicate in response in writing when we receive one of these written requests, advising the owner that the records requested will be made available. That does not translate into we have to email those documents to the owner within 10 days. They have to come in and inspect the records. They can use their own, portable device to copy the records, but we don't have a duty to provide them, electronically. The owner has to come in and inspect and copy. When we talk about other certain types of official records, such as telephone numbers, if you're going to publish a directory of numbers, you should get the consent of the owners before doing so. Emails are not considered an official record unless, and here's the big unless the owner has consented to notice from the association electronically. Once an owner signs off on one of those forms and specifies their email address, that becomes an official record of the association. Why does that matter? Well, if an owner requests to inspect email addresses and the association has acquired emails through its operation, business operations, but we don't have any formal consents on file, an owner is not entitled to those email addresses. And then if we have a board member using those email addresses to communicate with the membership during an election cycle, and they gain that information by use of their position, that's a problem, and that's something you need to consult legal counsel over, and we've seen that over and over again. If a member of the board is not reelected or resigns, they have 5 days to turn over any records within their possession, any official records or property of the association within 5 days. And if they fail to do so, there are civil penalties for that. We talked about the right to inspect. In terms of whether you can charge personnel time and copy costs, you can if it's more than 1/2 hour to retrieve the records. And if you're using the association's copying equipment, you can charge up to 25 cents a page if the copies exceed 25 pages. It has to be more than 25 pages before you can start charging. So the first 25 pages are free. We talked about the owner can use their own portable electronic device to make copies. That's perfectly fine. Now, real quick, let's talk about what records are protected. Any communications from your legal counsel is considered attorney-client privilege. Information the association obtains, through the screening process of sales and leases or other ownership transfers, that's confidential. So if somebody wants to see a lease agreement that we obtained, through the screening process, that's not something an owner is entitled to inspect. Personnel records, again, this is employees of the association, those are confidential. Medical records, if somebody has an emotional support animal and they had to submit a letter from a medical provider, that's confidential. And other personal identifying information is likewise
The
confidential.
phone numbers you did say were required to give consent.
Yeah, phone numbers, you need consent before publishing a directory, otherwise the phone number is considered protected. That's personal information. And we covered all this. If you don't respond to a records request within that 10 business days, it's a $50 a day fine, up to 10 days maximum, and the owner can file a small claims action to recover that. And if they have an attorney, they're entitled to their legal fees. Also, they'll file an administrative complaint, and you can be subject to fines with the department for failing to respond to a timely records request.
How about employee wages?
Yeah, so again, when we talk about employee wages and whether that's something that's a personnel record, we're talking about employees that are on the payroll of the association, not people who are part of the independent management company that may be providing you management services. And if it is an independent management company, their employees' information is confidential to that employer, and it's not something that we should be disclosing as an association, because they're not our employees. That shouldn't even be part of our official records. Okay. All right. Moving on to website regulations. I briefly touched on this. If your association has 150 or more units, you're obligated to have a website. And if you are obligated to have a website, you're going to have to have certain things set up on the website, including access to certain official records, notices, and budgets and other things that you're required to keep on your website. So for example, for our annual budget meeting is coming up, and we've sent out a notice to the membership by mail, also needs to be on the website and readily available for the members to download. And this is something that even if you're not 150 units or more, you still may want to have in place for your owners to encourage, transparency, as Dan was talking about, and communication. This is another forum to communicate through. And, of course, it can be set up so that members have to use a username and password to access official records. You don't want this to be a public website. We recommend that in order to maintain compliance, that the association own the domain name, whether or not whoever may be facilitating or operating your website for you, hosting it, the association should own the name, so that if relationships change, but you need to always have that website in place. Okay.
And they'll get a copy of these slides so
Yeah.
you can spin through.
Absolutely. Yeah. All right. So this talks about certain mandatory documents that have to be on the website. Your governing documents, we talked about bids and your budget and financial report. Those all have to be on the website. Contracts, insurance policies. You do need to have a very specific notice tab on the web page that provides links to notices that are required. We have the new structural integrity reserve study that condominium associations that are 3 stories or more are required to undergo, and milestone inspection. Those are now documents that are going to need to be on your website if you have to have a website. And those are documents that lenders may be entitled to once you have those available. All right. So drafting amendments, this gets into some detail that really is the subject of another class. But bottom line is, if you're looking to do an amendment to your documents, you're going to want to work with legal counsel to do so. One thing I'd throw out there is, and I know, we all try to be cost conscious. Sometimes it's harder for attorneys to review work product prepared by the board rather than going to counsel, telling them what you want to accomplish, and them simply, producing the amendment, as opposed to having to review and rewrite something that the board has prepared. So I'd talk to counsel first before we're talking about an amendment, explain what your objectives are, and then, of course, you want to know what it takes to get the amendment passed, and that could dictate how you approach the amendment process. Okay.
We're actually teaching that on the 15th.
Oh, super. Electronic voting. So electronic voting has gotten a lot of traction, not surprisingly, because of COVID. This was something that was less popular beforehand, but is gaining ground. So first thing I want to address with electronic voting is both the Condominium Act and Homeowners Association Act and the Co-op Act all authorize electronic voting. You don't have to amend your documents in order to implement electronic voting. Okay, so that's number one. Number two, the statute has a very specific process for implementing electronic voting. The board has to adopt a resolution. It has to be done with at least 14 days notice to the membership by mail. So similar to a special assessment notice, we have to mail out to the community written notice. The board's going to consider implementing electronic voting. That notice also has to be posted conspicuously on the condominium property, and there has to be a written form that owners can sign to consent to electronic voting. And also there needs to be a form in place for owners to be able to revoke their consent to electronic voting if they should change their minds. And there has to be a minimum time set to opt into electronic voting before the next meeting where a vote is going to take place. It can, and we don't have to use the voting system to elect directors, although we can. It could be you want to use it for an amendment because you need to get a high voting threshold to pass an amendment, and we want to encourage a high level of participation. The other piece that the statute addresses is what is the voting system required to do in order to be statutory compliant. And that's where, we get into some technicalities. And, the system has to be able to identify the owner. The system has to be able to, communicate, and there has to be a period of time to verify the system is successfully communicating with whatever device the owner is going to use, whether it's a phone, a computer. And so that period is 14 days in advance of the when the vote is going to take place. So when you think about how much time people have to opt in, you've got to take into account this 14-day period. So it's going to have to be some amount of time prior to that. So, minimum 20 days that people will need to opt into electronic voting. It may be that, your community has a vote on, whether to, fully fund reserves. While that's something we can still vote on, that's something you might want to use electronic voting for. So there's a number of things that electronic voting can be used for your association. And, in these days, just about everybody has internet access. So again, we talked about the adoption process. There's certain mandatory retention requirements of the voting platform in the statute. And so one thing I would recommend is if you're looking at implementing electronic voting, you're going to need legal counsel to put the package together for the board to approve at a meeting. And then you're probably going to want legal counsel to review that contract with the voting vendor to make sure there are protections in place, that there's representations being made by the vendor that they're statutorily compliant. All right. So next is budgets. This is probably one of the most complicated operational topics that we'll tackle and that the board has to deal with. And that has to do with putting together your operating budget and dealing with reserves. So I'm really only going to probably scratch the surface here. But one of the things to keep in mind is that as of, I think it was last year, the legislature modified the statute to state that the board must adopt a budget at least 14 days prior to the start of the new fiscal year. So we don't want to be waiting until the last minute to implement a budget. This is something we should start thinking about depending on what your fiscal year is. Most communities are a calendar year. So, we often see communities planning their next year's budget sometime in, end of August, beginning of September. Certainly, if you have a budget committee, that process is going to take longer. And depending on, how large of a budget you have and how complicated an operation you have, how far in advance you need to be planning. Your budget, your operating budget are going to be your recurring expenses that you always have year over year versus deferred maintenance, capital expenditures to replace assets. Those are going to be reserve items typically. The benchmark is anything that costs $10,000 or more is considered a reserve item. That isn't something that is a recurring expense. So, naturally, landscaping is a recurring expense. You're always going to have landscape expenses, but replacing the air conditioning in the clubhouse is not something we do, all the time. So that's going to fall into a reserve category. So these are just examples of your typical operating budget expenses. Insurance is an operating expense. It is not a reserve item. We have to have insurance year over year. And that's something that's been, probably one of the single largest expenses that condos have had to deal with in the last couple of years. And we're not seeing any relief there anytime soon, unfortunately. So, it's better to overestimate on the insurance line item than come up short. Again, when we're talking about reserves, there are certain mandatory statutory reserves, roof replacement, pavement resurfacing, building painting, and then we have a whole new litany of categories under the structural integrity reserve statute. And those include things like, windows and doors, Do we have a slide on that in this presentation?
I believe it's coming up. yeah.
Okay. So you want to make sure that if you're three or more stories, that you get going on your structural integrity reserve study, and make sure that you're going to have that in place by December 31st, 2024, because you're going to have to start funding those items starting in 2025. Okay. Now, moving forward, after December 31st, 2024, there's going to be some issues about what reserves, can you reduce or waive. Right now, as the statute reads, there are certain reserves that you can reduce or waive, and that requires a member vote. There's a disclaimer that has to be on the proxy. You have to do this by a limited proxy. The font for this disclaimer that you see on the screen has to be larger than any other font on the page. Typically, we put it right above the question where you're asking the owners to either partially fund or waive reserves.
And I think we're still waiting there's 2 legislative sessions to go before the deadline. We're still waiting on some clarification on that issue about the waiver and partial funding going forward.
Yep. And whether or not it's going to be just the assets that are listed in your structural integrity reserve study that you have to fully fund, or whether it's any asset that you have to reserve for that you have to fully fund. That's a big open question that we're looking for some clarity on. Hopefully this go around.
Do 2-story condos or less, do they have to have a reserve study?
Well, no, if you're 2 stories or less, I don't believe you have to have a structural integrity reserve study.
It's recommended that every condo has
well
one.
There's a difference between a reserve study and the structural integrity. The structural integrity reserve study is specific as to certain components, whereas a general reserve study is to all of the assets of your condominium. And that's something we talked about earlier, and the statute used to require that every 3 years. Certainly, every 3 to 5 years you should be considering that, because as you're putting together your reserve schedule, and one thing I should touch upon is, by statute, the board has a duty to adopt a budget fully funding reserves. Putting aside the legislative changes that just happened, the way the law has always been prior to that is the board has to adopt a budget fully funding reserves. The question of reducing those reserve funding or waiving it had to be put to the membership, and it requires a majority vote of those members present, at a meeting at which a quorum has been established. So in order to adopt a fully funded budget, we don't have to have a reserve study. You can use estimates that you get from contractors. For example, if you have an estimate or from a roofing contractor, or to paint the buildings, you can get an estimate from a painting contractor, but you should have some basis for establishing those reserve categories and amounts, and then also estimating the remaining useful life of each of those categories. So, this does get complicated. It's not something, you certainly should consult your management company if you have professional management to assist you with, formulating your budget and putting together your reserve schedule. Okay, so we have here SB 4D, which was adopted in May of 2022. It did 2 things. It created a mandatory structural integrity reserve study for all condominiums, co-ops, and with 3 stories or higher. And the study needs to be completed by December 31st, 2024. Strongly urge you get ahead of that, because I have clients telling me they can't get responses from reserve study companies.
Yeah, engineers
bids.
are 1 year or more out.
Yeah.
So you need to get on that bandwagon now.
Need to get on the list. Hopefully maybe the legislature will push this date, but we can't bank on that.
So Steve, if there is a reserve study that exists, does the board member have an obligation to use the numbers that are in it?
If you have a reserve study, the question is, are you obligated to use the numbers that are in the study? I would suggest that you do, unless you have some basis that the numbers are wrong. And if you have a question about the numbers, that's something to address with whoever prepared the study. I mean, just like with anything else, it's an opinion. Lawyers have different opinions. Reserve study specialists could have a different opinion. So if you think there's something fundamentally wrong with the assumptions made, then you need to get a second opinion.
And couple of other things really quickly. So the difference, and we do have a whole class on that. It was the legal update, and we will be continuing to expand on this when we
Right.
get the new legislation in for this year to see if there's any changes on this. But what's the difference between a structural integrity reserve study and a regular reserve study?
Yeah, so the difference between a structural integrity reserve study and a regular reserve study is the structural integrity reserve study, again, only applies to condos 3 stories or more and focuses on specific components of the building and those components that provide or impact the safety and structural integrity, just like it sounds, to the building. So if there's and this has to be done by a Florida licensed engineer, whereas a regular reserve study doesn't necessarily have to be done by a licensed engineer or architect. So for those who fall into that category, and if you're not, you're not sure what needs to be in the study, consult with your legal counsel. There are specific components listed in the statute, and then there's of course a catch-all phrase that any component that's at least $10,000 or more that in the engineer's opinion or architect's opinion affects the structural safety of the building has to be included. One of those items is the foundation of the building, which, we talk to engineers, they say, how do we put an estimated useful life on the foundation of a building, and how would, what that would cost? And there are things we're hoping will be fixed there. Windows and doors are another category that's listed in the statute, but not every association under their condominium documents are responsible to maintain, repair, and replace the windows and doors. So again, there may be some clarification coming there. But when we talk about, for example, resurfacing the pool equipment, the clubhouse roof, paving, those are things that fall outside the scope of a structural integrity reserve study that would be part of a normal study. And, if you're doing one, you probably should be doing the entire property and trying to negotiate a price for the whole property, not just the other. All right, so it's
Steve,
just that.
I know you're gonna move on
Yeah.
into assessments here in a
Right.
second, but with condominiums, they have to do their budget approval 14 days prior to the next fiscal year. So
Right.
it's January 1, it should be done by
Yeah,
14
December,
days prior.
no later
What
than December.
happens if they don't make the 14 days, and can you roll over the budget?
Yeah, so the question is, if you don't adopt your budget within the 14 days prior to the new fiscal year, does your budget roll over? Yes, technically it does, but you also have a statutory compliance issue, and if an owner wants to give you a hard time and file a complaint with the department, they can file one, and you're going to get cited. So, and then also you have to check your governing documents, because there may be certain requirements in your bylaws that require you to hold a budget meeting even earlier. It may say that you have to provide a proposed budget to the membership 30 days prior to the meeting at which the board's going to adopt it. I've seen provisions like that. So it's not just the statute that may apply to your budget process and what your requirements are. So when as new directors, get with legal counsel, make sure you understand what some of your critical deadlines are, especially when it comes to budgets and levying special assessments. All right. We're going to talk briefly here about assessments. This is probably the topic most people are familiar with, because this is something we write a check for either every month or every quarter. But this is how we fund our budget, is through the assessment collection process. I'm just going to give you a quick overview of that. Your documents are going to dictate how frequently assessments are due. They're going to indicate when assessments are considered delinquent. Typically, they're going to specify the interest rate that you can charge on your assessments and on delinquent assessments, and whether or not you're entitled to charge an administrative late fee. So that's all going to be document driven. Once assessments are delinquent, you have to provide by statute now a notice of late assessment to the owner. You cannot charge any legal fees for that notice of late assessment. It has to be sent to the last address on file with the association by certified mail, return receipt requested. You have to have an affidavit in the official record saying you sent that letter to the owner at the last known address for that owner. Okay, and they have 30 days to pay. And if they don't pay, then you can move to the next step in the collection process, which is typically handled by legal counsel. And that is notice of intent to put a lien on the unit. That's a 45-day notice. So the owner has 45 days to comply. Also has to be sent by certified mail. And then if there is no compliance and payment at that point, you move to recording a lien on the unit and sending yet another letter for 45 days, which is notice of intent to foreclose that lien that you've just recorded with a copy of the recorded lien. So when you look at this whole notice process, we're talking about a minimum of 120 days before the association can file a foreclosure action to force the sale of the unit to satisfy the delinquent assessment obligation. So, that's the collection process in a nutshell. I strongly recommend you, if your association doesn't have a collection policy, that you go ahead and implement one so that everybody is on the same page and they understand what the ramifications of not paying assessments are. Okay. And there's other things you can do to encourage payment, including suspension of use rights, and that gets into some more detail, which we cover in other classes. Okay. Financial statements. So this is the reporting requirement to the owners, which we briefly touched upon. Depending on, I'm going to jump ahead here, depending on your budget amount, where you fall on this list, whether it's your annual budget is less than 150,000 or you fall into these other categories, is going to dictate the level of review you have to provide your owners in terms of financial reporting. So if you have to provide a full-blown audit because your budget, including reserves, is over $500,000, and you're going to have a CPA prepare that. If you're just providing a report of cash receipts and expenditures, that may be something management does, or you do internally if you're self-managed. The reporting requirement, whatever they are, has to be satisfied within 120 days from the end of your fiscal year. So that financial statement or report has to be available to your owners within 120 days at the end of the fiscal year, and notice has to go out by that point in time to your owners that report is available.
At no charge.
At no charge, right? Your association as a corporation, just like you have to file an annual report with the state of Florida, you need to file an annual tax return with the IRS, and that's something that your accountant can handle for you. Okay, we addressed all that. I think, let me see, we talked about the whole collection and assessment process. The other thing that you should be aware of in the assessment collection process is if you have a delinquent account and somebody is looking to pay off the account, they may request a payoff or an estoppel, or if there's a sale that's going to occur and there's delinquent assessments, the closing agent may ask your association for an estoppel. There's a statutory form for the estoppel, okay? And that form and what needs to be contained in that form is all driven by statute. And there are certain caps on what you can charge for preparation and delivery of an estoppel and the time frames for providing that estoppel. So if you don't have a professional management company that you're under contract with who provides this service for you, you're going to need to implement a written resolution that legal counsel is going to need to prepare to authorize the association to charge estoppel fees, and also for the law firm that you engage to do your collection work to charge those estoppel fees. So if you don't have an estoppel fee resolution in place, you need to get one in place. Okay. One of the things that gets noted on the estoppel, in addition to the amount of the assessments, how much is outstanding, when the next installment is due, and if there's any special assessments that have been levied and due, is also if there's any violations of the rules and regulations outstanding. That's number 8 on the questionnaire. So that's a very important thing, that if there is anything outstanding, that gets noted so you don't waive your rights to enforce your rules and regulations. Okay. And this is where we get to the end of our presentation, which we're going to just briefly
favorite topic.
Yeah, it's my favorite topic. Yeah, ESAs. So this is probably one of the most complicated areas that we have to deal with for our clients, because unfortunately the law is very heavily in favor of the requesting party, which can be a unit owner, it can be a tenant, it can be a long-term occupant or guest of the owner or tenant. And as long as certain minimum requirements are satisfied, the association is put in a position of having to waive its pet restrictions. If, for example, you're a no pet condominium or you have a limit on the size, weight limit on the size of the pet, then you may have to make an exception to your restrictions that you don't like. So anytime you get a request for a pet waiver based on a service dog or emotional support dog or whatever label they throw at it, I strongly recommend you consult counsel, because there's a lot of guidelines that have to be followed under state and federal law for that. So, and with that, are there any other questions?
So yeah, I know, we do teach another class on ESAs, which we'll be teaching, I believe, sometime in March or April, so I will get you all that information. That's actually going to conclude the presentation. We do have a number of questions that I want to get to, but if you need to go and you don't have any other questions, you are free to leave. But we are going to, as I said, go through some of the questions that some of you have been very patiently waiting for. So for those of you that need to leave, thank you for attending, and your certificate will be emailed to you. Please check your spam bin. I do utilize a third-party service that integrates with the Zoom information to get your certificates out to you. So if you don't see it, please check the spam information or spam box. So with that said, let's start, Steve, on some questions.
Okay.
If a condo unit owner dies and the condo is passed on to a relative via a life estate deed, does the new owner need to be approved by the condo board?
So that's going to depend on how your condominium documents are drafted in terms of your rights to screen owners. I mean, you're not going to be able to stop the transfer of a unit by virtue of the owner passing away. Ownership is going to transfer. The question really becomes is whether the new owners who were heirs have a right to occupy the unit. So for example, if you're a 55 plus community and the adult children of the person who passed away is not 55, they have a right to own the unit, but they won't have a right to occupy it if they don't have somebody who meets the age threshold. Whether you have a right to do a criminal background check or credit check and those types of things is going to be specific to your community documents.
Thank you. We have some rules that have been overlooked and not enforced for several years. How can we start enforcing those rules, or should we change the rules to allow the behavior that's been going on?
Yeah, so those are really two different questions. If we have rules on the books that are not being enforced because as a community we've determined, or as a board we've determined those rules don't make sense anymore, as things have changed over time, then yes, I think it's a good idea to change those rules so somebody else can't come along and say to the board, hey, you're not discharging your fiduciary duty and enforcing the rules and regulations as you, association board, have published them. If you want to enforce those rules and they have not been enforced in the past, then you need to get with your association's legal counsel to discuss how you go about reviving those rules, republishing them, and enforcing them uniformly on a go-forward basis. There's going to be a whole process and notice that will need to go to the community at large and to implement that.
Awesome. Is the addition of additional cameras considered a material alteration?
So the general answer to that question is yes. Adding cameras to the condominium property is typically considered a material alteration. There are exceptions to that rule, and that's going to be driven by the association's ability to show that there are actual genuine safety concerns based on a record of criminal activity in the community. So that's something you're going to need to talk to your association counsel about, get an opinion letter. Again, your documents may have a spending threshold that allow you to spend a certain amount in a given calendar year without a vote of the members. So these are all things that, you need to talk to counsel about.
Great. And same thing, if a board wants to build a new structure that would be causing noise and blocking view, that is a material alteration.
Yeah, anytime you're building a new capital improvement, so I want to put in a basketball court or something that wasn't part of the original design of the community, that's going to be considered a material alteration. Changing the color of the building is a classic example of material alteration. The only exception I can think of is if it's mandated by the local government authority. So for example, I know City of Boca Raton has mandated high rises on the beach to be white. So if you were beige and you're doing a painting project, you're going to have to go white, and there's nothing you can do about it. That would be an exception to the voting rule.
What if the board members find that outside the contractors are coming into the building, but they're not doing what they're supposed to do? How can they enforce action against individual unit owners, contractors?
Yeah, that gets very complicated.
That's an individual.
Yeah,
legal
that's
counsel.
that's going to be a legal counsel question to your condominium association attorney.
All right. Are there any requirements for location and facility of a board meeting? Like, do you have to have it so close to the unit or at the unit, or?
So the question is does board meetings have to be conducted within a certain distance of the property or at the property? No, there isn't any statutory requirement. Again, this really becomes a question of not having the appearance of trying to exclude members from being able to participate. But if your community doesn't have the facilities to host the number of members who may want to show up in person, then it's appropriate to hold the meeting off-site at a reasonable location, based on cost considerations and things like that. So that's certainly something your manager can help you with.
Awesome. Required inspections of like sprinklers and the air conditioning units, things like that. What can the board do to get owner compliance with keys, and how can they better facilitate that process?
Yeah. So that the best way to facilitate the process of making owners maintain certain what I call high risk components to your condominium building is to amend your declaration to implement some provisions that give the association certain authority with respect to high risk components, such as air conditioning units, water heaters, the circuit breaker in the unit. Certainly the association has rulemaking authority when it comes to the condominium property, protecting and preserving the condominium property, because we all know when we suffer a water loss in the building, it causes substantial damage to units, it causes substantial inconvenience to the owners affected, and it causes a significant increase to our insurance premiums, which in this day and age, we're trying to do everything we can to avoid claims so that if we have a major, catastrophe, we reserve the policy for those types of claims. So, you can implement a number of different things, get with your association counsel on, mandatory inspections of certain components, requiring keys. You may have to go so far as bring legal action to compel certain owners to do certain things. And there may be no way around that.
Awesome. How do you enforce fines for violations?
Yeah, so enforcing fines for violations in condominium land is limited. Certainly, it's something that if a unit turns over, it's been properly levied, you can include it on the estoppel and collect it that way. If a unit is rented, there's mechanisms to collect the rent from the tenant to satisfy the monetary obligation to the association. But we don't have lien rights for fines on condominium units.
Great, but we can lien regular assessments.
Yeah, regular assessments you have, absolutely.
And what's the requirement for special assessments when there's an emergency, like a hurricane or hurricane damage?
Right. So when you have an emergency, which when we talk about an emergency, that we're talking about a declaration of emergency that's been made either by the local governmental authority or the state, the governor. And then the emergency powers statute would kick in. And then the association has the ability to levy special assessments in order to respond to the emergency event, in shorter fashion than the 14-day requirement. But again, if you're in that situation, depending on how severe, try and reach out to your legal counsel for guidance. Hopefully they're up and running and they can respond to your questions and concerns.
Awesome. How about, can renters attend meetings
Renters do not have a right to attend board meetings
or any meetings?
or any
really?
meetings for that. Yeah, they don't have a right to attend owner meetings or member meetings. They have a right to the rules and regulations of the building, to inspect the rules and regulations.
So we're out of time. I'm gonna
Yeah.
take one or two more questions, but, on ESAs,
Yeah, that's a whole nother class.
I know that's a whole class.
Yes.
But what do you do if you have owners that have allergies and things and they move to a building that was, animal
Right.
free for that reason?
Yeah, no, it's a problem. So, you have one owner who's saying I need an accommodation for my dog, and the other owner saying, well, that's causing me to have, other problems. It's a very complicated issue and goes beyond the scope of this seminar. So I'm going to punt that one.
We do that other class. We're gonna do it in March or April.
Yeah.
And if adding a pickleball court, converting a tennis court to pickleball, is that a material alteration?
Yes.
That's one of our favorite
Yeah,
fights
yeah.
that happens.
Until the
often.
legislature determines that converting tennis courts to pickleball courts is not, the answer is it is.
And the questions are just continuing
Yeah,
to
so
pour
we're
in,
gonna
so
have
we're gonna cut it off, but if you have any real great need to speak with us, please feel free to email. I'm gonna email all of you that attended a copy of the presentation, and we thank you all for attending. Dan, I don't know if you're still on here, or
Yeah, he is.
Ashley.
Yeah.
Yeah, thank you. Thank you very much, Steve and Katie. That was great. You guys are question answering machines. I think you gave away $7,460 worth of legal advice today, at least. So that was amazing.
I appreciate that. We appreciate the opportunity.
We try to give away free legal advice at all these classes as much as we can. So thanks again for having us, and thank you for attending, and we'll get your certificates out by Friday. For any of the CAM managers that are in attendance, please allow 3 to 5 business days for the DVPR to reflect your credits. We do have credits for this class, but it's been taking the DVPR a little bit longer than normal. It used to be 24 hours, now it's 48 to 72. So please allow a couple days to see those credits. And that's all I have.
All right, Dan. Well, thanks for having us.
Thank you for having
Thanks
us.
again, everybody.
Appreciate it. Have a good day.
Appreciate it. Great
Take
course.
care, everybody. Bye-bye.
Thanks for watching. For more great educational content, click the subscribe button now.